the first time that we tried doing this, we said, okay, we need a catchy tune. And so we tried basing it on Gangnam Ho. And we said, as many of you know, the catchy number, the racy number, we tried theming it and we called it open access style. Right? Then when we took it, of course we wrote I'd written the lyrics for that, and then we took it to someone who's again an alumnus of this institution, and who decided not to practice the law because he was gifted with enormous, prodigious musical talent, and so he turned his attention towards music, John Daniel. Right? So I asked him to be present today, but he said, I don't want to relive memories of my classes here. So, so I'm happy to do the music and the other things, but count me out of attending it today. So John Daniel actually worked on the music, and he said, I can't do music to Gangnam Style. It's too fast and it just doesn't go with the lyrics too well. So can I slow it down a bit, because he's more in the, he's got a little more of a flavor for country and a little softer music. And so then we rewrote the lyrics together, me and John, and made it a little simpler, little more mellow paced, and then he set it to music. We couldn't make the video, but we have the lyrics and we have the music. So let us know what you think, and I think we've already roped in our first partner into this, because when we went to the animation guys to animate and get a nice animated video, their budget is quite huge, and I had no idea that animation takes so much money these days. But we're again happy that is Prashant here, the software SFLC, Prashant Suganath. The SFLC has decided that they will also come in and partner on this and lend us some funds so we can get a nice snappy video and animated version out of this. But here are the lyrics and here's the music.
Knowledge is free, so they say, but intellectual property will make you pay. That legal spin can't wait to begin. Sue your blues away. So much for collaboration and my artistic salvation. Corporate dissipation has taken my bacon. Gotta sue these blues away. Commons right. Let's put IP in its place. Commons right. Let's get out of this rat race. Open access, open source. They're phenomenal, of course. Yeah. Let's put IP in its place. Exclusive patents and animated rights. We've gotta stop this sort of selfish fight. Master Yoda trying to own yoga. Gotta sue these blues away. Commons right. Let's put IP in its place. Commons right. Let's get out of this rat race. Open access and open source. They're phenomenal, of course. Yeah. Let's put IP in its place.
Panelists for the next session to please come up here along with the moderator, Professor Ramkrishna. And over to you, Professor Ramkrishna.
Well, good afternoon and welcome to the post-lunch session. Mr. Shamnad has already warned us that if you are very sober and do not take up complicated issues, perhaps they would sleep, right? And he's also warned us that none of us should should agree upon a particular point. There should be more disagreement, right? Should always agree. Fine. Afternoon session is on open standards and licensing, mainly on standard essential patent related issues. And we have with us as panelists Mr. Rajiv Chowdhury, an IP lawyer, Professor Yogesh Pai from NLU Delhi, Professor Natasha Nayak from Jindal Global Law School, and Mr. Navneet Hrishikeshan is going to join us anytime now. There are major issues relating to expressed that they should give up with this disclosure policy once for all and then focus more on the licensing policy in the IP policy. Well, we'll debate on that particular thing. We have now with us Professor Yogesh Pai. Yogesh Pai, who is now assistant professor at National Law University, Delhi, has been teaching intellectual property law and policy. He has worked with South Center, Geneva, Center, New Delhi as well. And he was MHRD chair coordinator at NLU Jodhpur previously. Professor Yogesh Pai has been on the roster of consultants of WTO. He facilitates as resource person for WTO's regional trade policy courses. And he is also serving as legal member in an ad hoc committee constituted by Government of India to assess granting of compulsory licensing for affordable healthcare in India. Over to you, Yogesh Pai.
Thank you. Thank you, Professor Ramakrishna. Thank you, Professor Bashir, for inviting me here. It's indeed a pleasure to speak among this audience. What I'm going to do is to briefly look into some of the issues, cutting-edge issues, at the interface of open standards and SSO IPR policies. Now, Rajiv did a good job of explaining you the basics, so everybody is clear as to how standards are formed, what they are, and what kind of implications they do have on the market. Now, what I'm going to try and look into is there any kind of consensus on what amounts to or what are open standards? That's the first question that we need to ask. Then I'll try and get into what is this whole game about? Is it a game about capturing value? And if it is about capturing value, what are the various models through which value gets captured in relation to standards? And how do SSO IPR policies contribute to it in either creating value or in terms of capturing value? And whether these policies are elusive precisely because of the dynamics of the market. So that these are some of the issues that I'm going to look into. And then I'm also trying to look into some kind of empirical evidence on SSO IP policies. There's fair bit of work. By last year, there was this serial center study on SSO IPR policies, which has thrown out a lot of data on various kinds of SSOs, the policies, the reasons why they are different, and all of the data is available for those who want to do further research in relation to SSO IP policies. And finally, I'm going to throw some questions out in the open to in terms of what are the right set of issues or questions that we all need to ask, because the question seems to be in relation to especially in relation to SSO IP policies, they are kind of structured in a way where we have to answer for a but for world situation, and a but for world situation would mean that we do not have adequate comparisons to make, if not for the current situation that we are into. So how do we address those questions in a but for world? For example, briefly, the question of innovation, whether IP promotes innovation. So how do we know that whether IP promotes innovation or not in a but for world? But for IP, what would have been the rate of innovation, right? So these are some of the important pressing questions, and let's look through some of it. So what is the consensus on open standard? Well, frankly, there is no consensus. Openness in terms of standardization may relate to openness of specification, whether the specification itself is being charged because they have copyright on the specification. Some do charge, and a lot of them are freely available. Then questions of openness in the drafting process of the standardization, who gets involved, who doesn't get involved, whether there is the membership is available to a lot of market players. And third is the question of ownership, who owns what kind of intellectual property on these in relation to these standards. So these are kind of the three pillars. But having said that, Matkowski in his article has identified at least 5 factors. There are others who have identified at least around 10 factors, Kretschmer and others who have done that. Basically, it talks about permeability to stakeholders in terms of their ability to participate in the standard setting organizations and what kind of openness is followed there. Transparency in terms of the process, whether due process is being followed or
That's not me saying it. That's one of the US district courts actually went and tried to figure out how many patents were there, right? So, since we are in an educational institution and I cannot swear, I'll just say that's simply ridiculous, right? That's not really the way this whole thing works. But it's there. And the reason it is there is because people try to get in to the standard setting bodies and try and get everything under the sun brought in. So what we would expect as a fairly responsible corporate citizen would be that the standard bodies try to control the kind of patents that are actually classified as essential. It's not somebody comes in and says it's essential and therefore it is. There have been some cases where they have actually gone in and seen if the patents can be anticipated from what is there before. There are some of the more informal SSOs which actually do a good job here, right? The second part of which we come to is the royalty piece or the licensing piece. So, as an employee for a for-profit enterprise, let me tell you, I do not like royalty-free. Okay, I think it doesn't really work for us personally. But keeping that aside, I think it makes sense to have a clean brand. I don't like that term too much. Reminds me of some kind of Facebook messages you get from certain parts of this country. But I don't get them because nobody wants to be my friend. But keeping that aside, the issue is basically how do you make it reasonable? How do you make it fair? And again, we see situations where companies use this model or have joined a SSO and try to control or basically monopolize people, the usage of these terms, right, or the usage of their licenses. And the main issue that comes out of this, besides the license terms that flow through and what you can do with them, is the money, frankly, right? We had a situation again in the Wi-Fi space where one of the so-called patent trolls came and said they want $2,500 for every location where a Wi-Fi network is set up using Cisco equipment, right? So it could be a coffee shop, could be could be law school, could be anywhere. Keep in mind the average cost at that, depending on the corporate size of the entity, the average cost of the access point was about $5 to $10. So they're asking for 2,500. Probably works for a large university. Definitely won't work for a small coffee shop, right? The court finally, it's kind of interesting. The court finally awarded them 9 cents per access point. So 2,500 to 9, I think it's 9.5 cents, right? So there is a big difference in the approach here, and I think that is creating an issue. I think we spoke about and there's also the whole thing going on in China, right? And I wouldn't normally use China as an example of judicial overreach, but in this case, there was a case involving one of our friends, Huawei, where the court laid down the rule that the royalty that you charge cannot be more than 0.19% of the value of the product, right? Now, we can argue about whether that is what it should be, whether it should be a piece of the component that is there. But generally speaking, I think there needs to be more thought given to this area, right? To avoid the situation where somebody just comes and holds you hostage at that situation. The final one that I will try and cover here is injunctions, right? Again, another model used here by many companies around the world. There have been some case law recently in the US and others where they've tried to put some parameters around what can happen. But personally, I believe that injunctions don't apply in this situation, right? Because if you look at the core principle or the core basis of why you go and apply for injunction or why you receive injunction, it is based on whether the damage that's coming to you is something which cannot be prevented just by paying money, right? And in these cases, it's all monetary. All the claims are monetary. They will say you need to pay me royalty. So it's being misused. Some of the US courts have come in now and said that only a member of this SSO can actually go and file for injunction. But I think that's still a bridge too far, right? Injunctions, once you have joined an SSO, once you have put your patents in there, and once you have agreed to license things on frank basis or whatever the terms are of the SSO, you should have no right to be able to go out there and stop people from using it, right? Yes, you can go and claim.
Chinese Chinese manufacturers. So you see a rise in their share in the market, the world market right now, based on the unit sales. There are 3 of China's players that are now in the world market, Huawei, Xiaomi, and Lenovo. These are all in the world market now. The Indian telecom sector, well, in 2008 onwards, more choices were brought in. That's when a lot of players entered the market. And based on the, again, the market is pretty competitive. If you look at market entry over a period, shipments increase in market shares of domestic manufacturing companies, several players in the market, average selling price coming down. So this is the mobile market share right now, where you can see it's pretty fragmented. It's not a concentrated market. There are several players. Indian players are doing quite well in the smartphone sector in India. There are a lot of vendors that are of Indian origin that are dominating the Indian market as well. I mean, at least they have a serious presence here. The shipments have been quite substantial. Average selling price of smartphone in China and India both have been falling. At least that's what it has been till 2015. In 2016, actually, the last quarter, the prices have been rising, but we'll have to see if there are too many variables that could go into that. It could be that there are certain competitive concerns, or there could just be that consumers' preferences have shifted as a result of their buying power. So in the backdrop of the cases that we have pending before the commission, that the commission is investigating, I just wanted to end with the importance of the balance that needs to be struck between anti-competitive effects of standardization and with the pro-competitive benefits, and the role of the CCI needs to be more evidence-driven, because at the moment, like we saw, the Indian telecom sector seems to be competitive, but if there is likelihood of royalty stacking and hold up, then that needs to really be studied. So that's one thing that needs to be looked at carefully. But ex post regulation should be the last resort when there is really AAEC is the appreciable adverse effect on competition. If there is an impact on competition that is seen, or there is evidence of that, is when the ex post intervention must happen. And in the meantime, the ex ante regulation by the SSOs can play a major role in terms of furthering openness and competition in the telecom sector globally. Thank you.
Quickly refer to one or two studies that have been done in relation to the ACPs. In USA, there was a study done of 380 ACPs which were asserted in the courts. The study scanned between 2005 and 2014 cases, and in which infringement of valid patents was held only in 16% of the cases, whereas in 34% of the cases there was success rate in non-ACPs. A similar study was done with respect to 58 ACPs in USA, Germany, Korea, and Japan. Out of 58 ACPs, only 7, that is 12%, resulted in infringement of valid patents, whereas remaining 88%, right, either they were not infringed, or they were invalid, or they were dismissed on other grounds. As far as European litigation validity outcome is concerned, another survey which has been done, where when the validity was questioned, around 31% were held to be invalid. So 20% ambiguous and 49% were valid, which means two issues. One is the over disclosure, and there may be, in the course of negotiation with the standard implementer, other terms may also creep in, and one of the other terms could be that they should not question, number one, the essentiality, number two, the validity, and they can also tie up ACPs with non-ACPs, which would lead to the anti-competitive activities. Well, with these few remarks, the floor is open for debate. Questions? We'll start with, yes.